At its heart, it's a national collection of criminal jury charges, but it's more than that. Every charge is accompanied with a review of the jury charge, including the impugned language, and then the appellate court, either a court of appeal or Supreme Court, ruling on that language. So in essence, you have a review which highlights the instruction, whether it was accepted or not by an appellate court, and the full text of the criminal jury charge. I think there's three primary groups that would be highly interested in this. First is lawyers, Crown prosecutors and defense lawyers, either trial level or appellate level. The trial level lawyers would be looking at this at the time that they're doing a jury charge when they come to the charge conference. They would have access to full text jury charges and instructions that have been either upheld or rejected by a court of appeal that they could urge their judge to rely upon. The second group that I think would be highly interested in this would be the judiciary, especially Superior Court judges across the country. Jury charges are no doubt one of the hardest things for judges to craft and are always the subject of appeal. So having access to something that one of their colleagues, another judge, said in another case, which is upheld by a court of appeal, I think would be highly beneficial to them in crafting the precise language in their case. The third group that would be interested would be academics, law school professors. There's been a lot of attention lately to some high-profile criminal jury trials around the country and instructions provided by trial judges. No doubt there's some professors out there who are doing research into this, looking at the jury system as a whole and criminal jury instructions. It's unique in two ways. It's unique because it's an original substantive material, but it's also unique because it fills a gap that's been existing. If you read almost any appellate case out there that deals with a jury charge, what they will often say is that the impugned area of this charge was maybe problematic, but when read in the whole context of the charge, it was fine. What you have access to now is the complete charge that never existed before. So the area this will assist counsel with is having that complete charge and having effectively appellate-proof language that they can encourage a judge to include in the charge for their case, and judges have access to the same kind of appellate-proof language that they can refer to and cite in their jury charges. Until now, people haven't had easy access to that charge or any other charge because the courts of appeal don't include the whole charge as part of their reasons, only portions of it or sometimes only summaries of what a judge said. So now you'll have access to the entire charge from that case or any other case as well.